It's a very great pleasure to invite you all to join us for this session of the Alumni Festival 2020. I think I speak for my co-presenters to say that we are really glad to have the opportunity to talk about the problems faced by many women within the criminal justice system. And I hope that you will find that there's a lot to hold your attention within this very short session. The first speaker in our presentation is Professor Loraine Gelsthrope. She's director of the Institute of Criminology. She's been a fellow and tutor for graduate affairs at Pembroke College for a very long time. She's extraordinarily busy around the university, where she chairs numerous committees, including the vital University Postgraduate Research Committee, and her commitment to student welfare is legendary. She's played, and she continues to play, a leading role in British and European criminology, and her research spans a huge range, but a theme might well be the links between criminal justice and social justice, looking at race, gender, social exclusion, women and sentencing, crime and justice. She's not only a hugely respected academic, but she has hands-on commitment to challenging many current ills, such as, for example, modern slavery, human trafficking, and nobody could be better placed to speak here today than Loraine, so I'm handing straight on to her.
Well, thank you very much for this invitation to speak today. I'm very pleased to do so. What I want to talk about is the case of short ladders and very long snakes when it comes to the imprisonment of women. A lot of people will be very well aware that in England and Wales and Scotland, we imprison people at a very high rate. And indeed, we're amongst the highest rate in Western Europe. And the prison population has grown by 70% in the last 30 years. The number of women in prison has increased enormously, as some of the figures of women in prison show. In the next slide. Indeed, at the moment, there are roughly 3,500, slightly above that, women in prison. That figure has grown enormously since about 1992. It's not always clear why that is so. If we look at the characteristics of women in prison, we can see that quite a lot of women in prison have difficulties and challenges of one sort or another. A very high proportion of women in prison have a mental health problem. A number of women in prison were in care as children. A great number of women have experienced abuse as a child, or they've observed violence in the home as children. School exclusion features in their background, and unemployment features very largely, with 81% being unemployed in the month before custody. Homelessness features very largely too, and in prison we can see that, looking at the characteristics of women, a very high proportion have attempted suicide. The use of Class A drugs is very high too, and there are alcoholic problems too, alcohol problems. So in the next slide, we can see reasons why women are there. And for the most part, women are there for property-related offences, theft, handling, and very often shoplifting too. 10% of women are imprisoned for crimes against society. And you may be wondering what crimes against society are. They are crimes where there's no direct victim. So criminal damage, being drunk and disorderly, illegal drug use, for example. And contrary to some media reports, only 10% of women are in prison for violence against the person. And when we drill down into the statistics, we can see very clearly that it tends to be lower level violence abuse, assaults, common assaults around pubs and clubs amongst young women for the main part. I think it's also worth my pointing out that 72 of the prosecutions for non-payment of TV licenses are against women, and 72% of prosecutions for truancy of children relate to women. Black women are more likely to be prosecuted than white women too, which is something that we should be very concerned about. In the next slide, we can see something of the sentencing patterns. And the key point is that the majority of women are sentenced for very small periods, very short periods, not very short, but they are short periods compared with men. So 77% of women have been given sentences of less than 12 months. And we can see that even over 200 women get a sentence of custody for less than 2 weeks. All this is very worrying, that we're giving so many women short sentences of custody when their offences are not amongst the most serious offences. So here there is a very short ladder, so to speak. Women don't seem to have to do very much to get a custodial sentence. Moving on to the next slide, I want to emphasise that there are short ladders. As I say, it doesn't take very much for a woman to receive, to be given a short sentence of imprisonment, even though a custodial sentence is meant to be a very last resort. And the Sentencing Council responsible for sentencing guidelines states, imprisonment is the most severe sentence available to the courts. Custodial sentences are imposed when the offence is so serious that neither a fine alone nor a community sentence can be justified for the offence. If we put that against the pattern of women's offending behaviour, we can see that there are a good number of questions to be asked. I think a particular challenge in the sentencing of women is the way in which women's high needs, given mental health problems, so on and so forth, the way in which those high needs are sometimes confused with risks. So somehow persistent petty offending amongst women who do have mental health problems and all sorts of other problems gets translated into high risk of reoffending. Sometimes sentences refer to such women as being dangerous too. Notwithstanding the government's own policy document, the Female Offender Strategy document, which they issued in 2018, which makes very clear a commitment for women to be diverted from custody, not much has happened in recent years to divert women from custody. And what we see is the effect, a devastating effect in women's lives and the lives of their children. In prison, as I've mentioned, there are very high rates of self-harm and suicide. And we know, even before COVID-19, the COVID-19 pandemic, prisons were have been judged to be unsafe. And Her Majesty's Prisons and Probation Service have noted in various reports that 38% of prisons are rated of concern or of serious concern because they're not keeping people safe, not delivering what they're meant to deliver in terms of rehabilitation. Of course, these challenges have been exacerbated by the pandemic. So we can point to an inefficacy of short sentences. And to add to the particular challenges that women face, we've seen an increase in recall to prison and breach. In 2014, new arrangements were introduced for the supervision of people experiencing a custodial sentence, even very short custodial sentences. The new provisions were well intentioned, that everyone should have 12 months supervision. However, that supervision doesn't always deliver what it's meant to deliver. And again, there have been particular challenges during the pandemic. What we find also is that women, as with men, are very quickly breached, taken back to court, not for reoffending, but for being in breach of the conditions imposed upon release. So being late more than once or twice, or missing appointments with their probation officer, can eventually lead to people being recalled to prison, taken back to court, and then given a short custodial sentence. So in the next slide, I really do emphasize that it's a game of snakes and ladders, and a kind of revolving door for a number of women who get repeated short terms of imprisonment, interspersed with what seems to be unsuccessful community supervision. And women do have complex needs, addiction, health problems, mental health problems, and homelessness. Homelessness is a particular problem, and a number of women in the last 2 or 3 years have been released from prisons with merely a tent and a sleeping bag upon release. The Independent Monitoring Board for Prisons recently carried out some research and noted that 50 to 60% of women leaving one particular prison that they looked at were leaving with no fixed abode, nowhere to go to. And although a letter is given to local authorities don't often see women as a priority, and there's a desperate shortage of hostel and social housing. So many women leaving prison end up on the streets, living rough and open to abuse, open to victimization from crime as a result of that. So I just want to very briefly say something about an accommodation project which I've been involved in, since I do think that accommodation is a major concern. And in the next slide, there are a few points about the accommodation project. This is an accommodation project led by a community rehabilitation company. Some people will know that the provision of some services in the community was privatized in 2014. Community rehabilitation companies were created to work alongside the probation service. So this is an accommodation project which I've been evaluating with a colleague. It's based in an English city. It's led by the CRC, working in partnership with a very large national voluntary organisation with experience in housing management and tenancy support. With support from a local women's centre to a community-based centre with a range of services specifically for women. Housing benefit meets some of the project's expenses with additional costs of support and staffing provided by the CRC. So the housing organisation leased a number of bedsits and small flats from local private landlords. It employed people to work on the project, undertake tenancy management, and who provide direct support to the residents. The city's Women's Centre, which has a contract to deliver some women's services, has been supporting the project too. However, we can still see snakes and ladders, or a revolving door of women coming in and out of custody. So I think, as I show in the next slide, one of the key points is that the whole project has been quite chaotic. We've asked a number of research questions, of course. Does it work? Has it been valuable? Has it been value for money? Do the courts understand the project? Are they sympathetic to the project? Does it work for the women? What do the women who've been residents in these flats and bedsitters, what do they say about it too? And critically, does the provision of accommodation reduce the potential for women to be recalled to prison? As I've said, one of the problems is the very quick return of women for being in breach of condition to return to court. So one of the findings really is that there is chaos. I think this is research which has taken me very close to the lives of women and to the challenges which staff face, and the concept of chaos has been central to real life research which we have been doing, and which I show in the next slide. I think one of the key points here is that these are women who, because of their very difficult backgrounds and challenges which they've faced, including drug misuse, including what they feel as forced sex work with no other opportunities for work, and with chaos in their own lives, they are described as a hard to reach group of women, and they really are hard to reach. So one of the key findings is that recovery and desistance take a very long time. Key finding: housing is crucial, but it's not a magic wand. It provides women with a stable environment from which they can attempt to deal with some of the other things. Another finding is that multi-agency work is very much required, but there also needs to be some sort of understanding of the difficulties of the women. So yes, there are mental health services, but if someone misses an appointment, they're put to the back of the queue. Yes, there may be drug services, drug misuse services, but again, if someone misses an appointment, they'll be put to the back of the queue. That's very difficult for women who are living these chaotic lives and for whom there is huge attempt to keep them out of prison. Maybe the final point to make is that persistence does pay off. There are some positive findings in the research, but it's very clear that long-term investment is needed. We need very long ladders. We don't need a punitive response. We need to avoid a punitive response in the way in which we approach things. And I think that involves seeking understanding from the courts too. And finally, in the final slide, I simply want to say that when we have talked to women about what might help them keep out of prison, reduce recall to prison, and so on, it's very clear that most women, perhaps most people, most women who've offended just want a normal life. They may have very complex lives at the moment with drug misuse and homelessness. But we have to deal with the homelessness issue in order to facilitate both a reduction in crime and a reduction in recalls to prison. So I wanted one of the women who've been part of the research to have the last word, and this is a word from Chile, and it's her vision of the future. And I think it's a very important vision, and very much one which I hope we can facilitate by doing work on women in prison and on sentencing. So thank you.
Thank you very much indeed, Loraine. There are questions coming in already for you, but we'll, I think, take all the questions at the end. We'll turn straight now to Naima Sakande, who, her background is she studied global affairs at Yale, and she's worked as a tireless defender of disadvantaged and often very vulnerable people at the receiving end of the justice system, including in the Bronx as well as in London. She's been manager of the Women's Justice Initiative at the NGO Appeal, based in London, for nearly 3 years. And there she's an impressively ferocious battle axe, challenging miscarriages of justice for women who are seeking to challenge unsafe convictions and unfair sentences, specializing in case investigation for appeals on behalf of women with histories of domestic abuse and mental illness. She's also vice chair of the charity Women in Prison. I had the privilege of supervising a research project that she undertook last year, supported by the Griffin Society and the Institute of Criminology here in Cambridge, and that's what she's going to talk about now.
Thanks so much, Nicky, for that really kind introduction. As Nicky mentioned, I want to talk about the research project that I did last year, helped very kindly by the Institute of Criminology and the Griffin Society. And it was really looking into the criminal appeal system. And why is that system particularly important in this area when we're talking about women in prison? Well, as Lorraine's really clearly set out, there are a lot of women in prison who don't need to be there and shouldn't be there, for whom community alternatives is probably far more appropriate. So I think it's really important that we look at the system, the mechanism that we currently have available to us to correcting mistakes within the criminal justice system. If something goes wrong within a criminal trial and somebody who's been convicted who shouldn't be, or who's gotten a sentence that is unjust and that they shouldn't have, the right recourse is a criminal appeal in order to get the system to correct that mistake. And that's why I thought it was particularly important to look at what the barriers are for women trying to appeal unjust sentences and unsafe convictions within the Court of Appeal. So the first shocking thing that I found was that since 2010, the rate of overall appeals to the Court of Appeal Criminal Division has dropped by 36%. That's an astonishing drop in the number of people in general, not just women, who are trying to overturn unsafe convictions and unfair sentences. Now, if you've followed anything about the criminal justice sector in the last 10 years, you'll know that we're not doing too great. So this isn't an indication that there's less problems or there's less going wrong in the criminal trial system. It's an indication that less people are accessing their right to appeal. Why is this particularly concerning for women? Well, if you think about appeals as a form of complaint, a system complaint, where you're saying, hang on, something's gone wrong in my initial trial, something's gone wrong and I need to fix it. We know from other areas that women are less likely to complain than men. So for example, the Prison and Probation Ombudsman did a study where they found that although women are 5% of the prison population, they're only 1.7% of all complaints to the PPO. And so we're really concerned that this drop in appeals, it actually severely negatively impacts women in particular who have particular barriers to access. So I went about trying to work out what was going on there. So throughout, I've used the words of the women themselves, because I think it's really important that they're sort of somewhat present within this talk. So you'll see their words written out here. So what did I do? I looked at 132 letters written by women who were in custody who wrote inquiring about an appeal to our charity. I did questionnaire responses from women in custody and also responses to a legal survey that was sent out to barristers, solicitors and paralegals who had direct experience of representing women in the Court of Appeal. And so what did I find? One of the most shocking injustices within this system is that there's an arbitrary time limit set in terms of when you can appeal a conviction or sentence. And the clock starts ticking from the date of your conviction and the date of your sentence. You've got 28 days to get your appeal in. It is possible to appeal out of time, but the procedural barriers to that mount significantly after that point, so you're much more likely to succeed if you get your appeal in time. And you'll find that 86% of the women writing to us for support were writing well outside of that 28-day window. So what was going on? Why were they not reaching out to us? Well, again, Lorraine's touched on this, that the vulnerability of women who are coming to custody is extraordinarily high. I think it's actually one of the most vulnerable populations in the country that you could possibly see. And so the arrival to prison is an incredibly traumatic event. You imagine you've been sentenced to custody, maybe you weren't expecting it, you were expecting to get a community order, and all of a sudden your housing's on the line, your children, who are going to take care of them, your job, any sort of stability that you have has been ripped out from under you. And it's an incredibly vulnerable and traumatic time. And so you can see this first woman says, I want to deal with this appeal process while I have a level of health and mental capacity to cope with it. Doing an appeal can be re-traumatizing. It requires going over the initial trial again, going over the facts again, getting your ducks in a row, and speaking cogently to a legal team about what's gone wrong in your initial trial. And that can be very, very difficult. And as you can see from the second letter, some women feel suicidal, broken, don't feel like they're living anymore. And the ability to get your head together in order to launch an appeal within that time is very unrealistic. One of the other issues we found in this research was issues of trauma and domestic abuse being disbelieved in the first instance trial. So here, for example, this woman's mentioned domestic abuse and was told that nobody, not even the judge, believed her. So this sense that something traumatic that's happened to you that might be critical to your culpability in an offence hasn't been taken seriously in the first instance trial is a real issue. And the other issue is that women were often not disclosing traumatic histories until well after the 28-day window, until things had calmed down for them in custody and they'd gotten their heads together. Suddenly they realized, hang on, this traumatic history, this abusive history is relevant to the commission of the offence and should have been raised either at sentencing or during the trial. And of course, at that point, it's far too late. So we found that histories of abuse were particularly late coming to the table. The other main complaint was about poor legal representation. And now this isn't just sour grapes, although it might seem that way, that women who end up in custody might have issues with their legal team. Women are writing with stories of really terrible experiences with legal representatives, writing to them, calling them, asking for updates on the case and not being told anything. Things like asking for evidence to be presented at trial that was never requested from the prosecution as part of disclosure requests prior to trial, alibi witnesses not being followed up on, some really egregious issues. But one of the main things that kept coming up was that women were upset that they'd spent so little time with their legal team, that they didn't trust their legal teams, and that lawyers were very bad at explaining what was going on in the trial process, and particularly the outcome of trial. There was this attitude of sort of cut and run. If you've lost, we'll send them a quick letter saying, sorry, you lost, here's the sentence, no, you can't appeal, and that's it. And so women were saying, my barrister never came to see me in the holding cell to explain anything, and I received this letter and I didn't understand it. That's a real concern. Something Lorraine's already touched on is the effect of maternal imprisonment on children. So we know that 9 out of every 10 children whose mother ends up in custody has to move out of their home. And that might be to the care of another parent or other family members, or to the care of the state, into the care system. And so we know, because of the patriarchal society that we live in, that women still tend to be primary caregivers of children and are more likely to be single parents. And so we know the ripple effects of maternal imprisonment are larger than for paternal imprisonment, and that's just true. And we know that there are sentencing guidelines that allow judges to consider the impact on a community of putting women in prison, but this often isn't taken into consideration. So you got this letter from a woman who said, my children are facing eviction and my daughter recently spent 4 days in hospital. She's just 13. So she's scared and lonely. And you can imagine, again, that clock of 28 days when a mother's dealing with working out what on earth's going to happen to her 13-year-old daughter on the outside, going through another legal process just isn't top of anybody's priority list. Now, I'd be remiss if I didn't mention the appalling criminal legal aid system that we've got in this country. And, the appeal system is a very small part of that, but just as with other parts of criminal legal aid, it is woefully, woefully underfunded. So within criminal appeals, for example, you aren't entitled to a second opinion on whether or not you've got a right, whether or not you've got grounds to appeal under the current legal aid regime. Now, the appalling thing is that for a lawyer to mount an appeal and say, yes, you've got grounds, it requires sort of marking your own homework. If I've been the defense barrister or defense solicitor, in order to say that there are grounds of appeal, I've maybe got to go back through what happened at trial and say, oh, maybe I made a mistake there. Maybe that evidence should have been adduced and it wasn't, or maybe I should have made that bad character application or whatever it is. And there's obviously a disincentive for you to argue that you were incompetent to a high court. So it's crucial that women are able to get a second opinion on what happened at trial, and that's currently not covered under legal aid. So you can see the solicitor says the system's been utterly starved of funding, which is very, very accurate. And so what's the conclusion with all of this? All of these factors mean that there's a real lack of confidence amongst women in custody to pursue an appeal. They don't know how to do it. They're not given proper advice by their legal teams. They're not believed when they mention relevant and salient facts about their background that might impact on their culpability, either at sentencing or to the commission of the offence in the first place. They don't want to raise a fuss because they don't want to traumatize or further traumatize their children or their communities who are now struggling without their presence within the community. And so is it any wonder that, you know, many women reply and say, you know, what's the point? What is the point of me going through this process again? And this is particularly common with women who come from difficult backgrounds, where they've become very used to the idea that their opinions and their rights simply don't matter. So what needs to change? I've split this in two. I think there are two very clear legislative reforms that need to be enacted. The first is the revocation of the 28-day restriction and to be substituted with a 6-month deadline to bring an in-time appeal. It is utterly unrealistic to expect somebody who's traumatized and has just arrived to custody to go through the very complicated administrative and legal rigmarole of launching a successful appeal. The second thing is we need a complete rethink of our criminal legal aid system, and that's true for appeals work and right the way through the criminal system. But in particular, we need to re-incentivize face-to-face contact. At the moment, you know, it's enough under the legal aid regime to send a letter to a client after you've lost a case or after they've gone to custody saying this is what happened. But we don't incentivize and properly fund face-to-face meetings. So bothering to get a lawyer out to a prison to meet somebody face-to-face to explain what goes on with them, what's gone on for them. And it's really crucial that we bring that back into the system. We also need to allow second opinions on the merits of an appeal. But fundamentally, what needs to shift is we need to shift to a criminal justice system that is more human, more humane. We currently have a system that is two-tier and that speaks two different languages. One is the language of defendants and jury members, everyday people who might not have had a lot of contact with the criminal justice system before. They might not know how the law works, how the police works, how a prosecution and a trial occurs. And the second system, the second language, is those of the lawyers, the barristers, the solicitors, the judges, who are speaking a completely different language, who argue about evidentiary standards, case law, legislation, statutes. And that is often impermeable and incredibly difficult for your everyday person who's going through a criminal system to understand. And until we can bridge the gap between those two and treat defendants as with respect and as agents of their own lives and as capable of understanding what is happening to them, we can't reach a system that can properly take into consideration their vulnerabilities, their needs, and treat them as needs rather than risks, to link back to what Loraine said. So at the heart of reforming all this, we need to get to a system that treats women with respect and with agency and allow them agency to make decisions that impact their lives. And that's true within the criminal appeal system, but it's certainly true across the whole criminal justice system. So that's me.
Thank you very, very much, both of you, for those very interesting talks. Before we go on to the question and answer, I want very quickly to be slightly provocative, perhaps, in talking about, so what should we do about this? We had a white paper on sentencing published last week. Some of you may have read it. To me, it was deeply depressing, very punitive in its language, quite a lot of rehabilitative hopes, but actually they were rather vague and often also very complex. There is an annex on female women offenders, identifying all the problems that they face, but the solution, oh, it's going to be really difficult to deliver. Nothing new, nothing has really moved on since the Corston report, and I find that extremely depressing. I'm an academic lawyer. I didn't introduce myself as I did introduce my colleagues, but I am primarily an academic lawyer in my working life. So I spend a lot of time reading law reports, and you'll see here, I've mentioned on my next slide, 2 law reports which are chosen really as great contrasts, but you would all be able to access them. If you Google those names, they're all freely accessible. The UK Supreme Court puts its judgments on its own website. That is a very lengthy judgment of Baroness Hale. It's fascinating, again, deeply depressing. I think the Secretary of State, as so often is the case, admits that he's in breach of his public law duty to provide accommodation for women. But the legal question isn't about whether he's in breach of his public law duty, which he admits, it's whether it's actually unlawful sex discrimination. The problem being that there are 94 approved premises, what used to be probation hostels for men, and I think in that law report it was 6 for women, none in London, and at the end of a very lengthy judgment, Miss Cole wins, if you like. It is unlawful sex discrimination. There are many, many problems that one sees in the law reports. Fathers, Miss Fathers is a woman also, as well as Miss Cole, convicted of murder very long time ago, both of them 2007. Miss Fathers comes up to the end of her tariff. She applies for parole. The panel, as I've put here, accepted that because of COVID, it wasn't possible to hold a fair hearing, either by telephone or video link, but it could be fair to do it on papers. They then decide that they won't direct her release, they won't recommend a transfer to an open prison. And I think from her perspective, she must be deeply confused. How could it be that she couldn't have a fair hearing by telephone or video link, and it could be fair by not hearing from her at all? That's an example of the recently invented reconsideration mechanism. And very interestingly, the Parole Board has chosen to make all of them public, and you find them on that Bailey website, which is the website of an NGO, a charity. There are many questions about the accessibility of law reports for us all. But the point really of raising those two cases is to tell you that I, of course, look through the academic lawyer's lens, and we get too used to it. So on my final slide, I encourage you to look at the issue through the lens of either Miss Cole or Miss Fathers, both women who spent a lot of time in prison, and they're stuck largely because of the huge need for investment, for money, to get things working. I think it's an incredibly challenging world that we live in. Of course it is. Listening to my speakers again makes me deeply, my fellow colleagues, it makes me deeply frustrated about what can we do more to build inclusive communities, not excluding people, not sending women, keeping them in prison for longer and longer. I should have said, I think at the very beginning of this session, something about the Cambridge Women in Law who are hosting this event, but instead I've put here a question: what should the Cambridge Women in Law do about this problem? It's a serious question that I ask you all. CWIL is a social network. It's open to all alumni who studied at Cambridge and who work in the legal sector. It was launched this time last year at an event which also coincided with the Alumni Festival, which marked the centenary of the passing of the Sex Disqualification Removal Act 1919, when women were finally allowed to practice law. Today, a year on, we've chosen to focus on women not as lawyers, but at the receiving end of criminal justice. And there are so many questions. I will read the questions, the comments with great interest to see what you think CWIL should do about the problem, and equally what you should do about it, what I should do about it. Writing to your MP endlessly seems rather a waste of time to me. Let's turn straight though to the questions and answers that we've been receiving. They've been pouring in. I don't know whether, Loraine, you've had a chance to look at them at all. There are a number which are very specific to your presentation, and I wonder whether you'd like to answer Gemma Silke's question, Brenda Thompson's question about how long can people remain in your accommodation project. I suspect you won't be wanting to say which city and which large national organisation, but if you could answer those two questions just for a bit more background on your accommodation project, that would be very useful.
Yes, thank you. We've only just submitted an evaluation report on the project, so I'm not at liberty to indicate where the project is taking place. Follow-on accommodation is very much in mind, and we've made some recommendations about that. Initially, I think it was assumed within the project that 6 months accommodation would provide sufficient stability for move on. That is rapidly being revised, and I think that the figure is more like 2 years needed in the accommodation provided in order to get on housing lists, and so the long process of negotiation with local authorities for housing.
Thank you very much indeed. Perhaps the next question can go straight to Naima. Julia Freitag's question about, do you think that the overly harsh sentences come as a result of the bench being unrepresentative, a lack of training about the issues particular to women, or that it matches the heavy-handed sentences being handed out to all defendants?
I think it's all of those things. I think the lack of representation on the bench is really crucial. I think with the Black Lives Matter protests and sort of BME issues being at the forefront of sort of the public mind at the moment, I think it's really important that we say that, for example, in the Court of Appeal, there's only one justice who is Black or minority. None are Black. There's only 30 BAME, there's only 30 Black judges, I think, in the whole of England and Wales. So lack of representation is massive. I do think, you know, Nicky, you mentioned the new sentencing guidelines. We have a government that's happy to be sort of tough on crime, and I think to take quite regressive steps when it comes to sentencing and to take a more punitive approach. So I am concerned about the next few years and what sentencing is going to look like as a result of that. So I think it's a mix. I think there has to be a cultural shift where we go back to understanding defendants as people, as complex people with often very, very complex needs. And I hope if there's nothing else that you've taken away from this talk, it's how complex the needs are of women who are wrapped up in the criminal justice system. And it has to come from the bottom up, from the top down. There's an awful lot that needs to be done.
Thank you very much. And then there's another one for you, Naima. What would your proposals be to balance an extension to the time limit for appeals with victims' rights to a speedy conclusion to the criminal trial process, noting that the extension would need to apply to all crimes, not just crimes committed by women?
That is a very, very interesting question. I mean, I think what's really important from a victim's perspective is that victims want the criminal justice system to get it right, probably more than anybody else. If you're a victim of a crime, you want to be absolutely certain that the person who's been convicted is the person that has committed it, and you want to be sure that the punishment matches the crime. And I think victims have the most vested interest in getting it right than anybody else within that system. So hopefully it's understandable to victims' rights that sometimes the system makes mistakes and it needs a proper recourse to fixing those. And what we're seeing at the moment, the first slide that I had showed that, for example, in 2018, only 64 convictions were overturned, only 64, and from 4 years before that was 120. So we've halved the numbers of convictions that have been deemed unsafe. Yet we know that the criminal justice system has become more and more the Wild West. We know that the funding's been cut to the bone. The Ministry of Justice had the most severe funding cuts through austerity. So we know that the risks of there being gaps and mistakes being made within the criminal process are increasing and not decreasing, yet our ability to fix those mistakes is declining. So I think it's completely compatible with victims' rights to extend that appeal process so that we can be certain that the people who are in custody and the people who were convicting of crimes are the right ones. I would be horrified to find out that I was the victim of a crime where the wrong person has spent time in custody. That's not the outcome that we want from a criminal process.
Thank you very much indeed. A related question, which I'll also start with Naima, but encourage you, Loraine, if you want to comment too, which is, with so many short sentences being handed down, is there any point in making an appeal? Another related question is, how does the shortness of a sentence relate to the appeal process? And then there's another question which I had in my eyes at one moment, which I've now lost, which is why are there so many short sentences when we know they don't work? So the first two, I think, for you, Naima, and the last one for Loraine.
Well, Nicky, you'll remember we went to an event right at the beginning when I started off my research project, and we were telling a judge who was there about the project and saying, you know, we think women might be appealing less. Why do you think that is? And he responded to us saying, because they're sensible, that, you know, because they know there's no point. And I thought that was really, really, really telling. There is a risk of indirect discrimination with women's access to appeals as a result of short sentences. We know that women get sentenced to shorter sentences on average than men do. And yet the appeal system, at the moment, the delays within the appeal system are pretty atrocious. So for a sentencing appeal, it takes a minimum of 6 months to go through the criminal appeal process. For a conviction appeal, it takes 12 months to go through. So that's administrative court delays, not delays on the behalf of defendants putting in appeal applications. So imagine you're going to prison and you've been given a 3-month sentence. What is the point of applying to have that sentence overturned if it's going to take 6 months for the court to even hear it, whereupon you're back in the community and you know, it's functionally an academic exercise. So there's a real risk there that because our criminal appeal system is not agile and because our criminal justice system is underfunded and we've got a massive backlog of cases that delays everything, that further reduces women's ability to correct mistakes. There's another issue around loss of time where actually judges can penalise defendants or appellants seeking to appeal and extend their sentence if they believe that the appeal is completely unmeritorious. And that also indirectly discriminates against women, because if you've been given a 10-year sentence, having an extension of time ordered for a couple of months to your sentence because you dared to appeal maybe isn't that big a risk. If you've only been given 3 months and your sentence might be extended by 3 months, that's a doubling of your sentence. So realistically, actually, when you're a short sentence woman, there is very, very little incentive to appeal. But does that mean that the sentence you've been given is unjust? No. So we actually really have to think about a better mechanism for fixing mistakes more quickly in order for short sentence women in particular to be able to challenge those sentences. We've seen instances of judges sentencing women to custody because they can't find a community alternative and they think it'll be safer for the women to give them a custodial sentence than to give them a community sentence. That just cannot be right. That cannot be right. We cannot be using custody as a default because we've got nowhere better to stick women. That's a horrific indictment of our society if that's the level we've stooped to.
Thank you. Loraine, could you follow on from that? Neve Gallagher asks, why are short custodial sentences so frequently given by the courts if they are in fact ineffective? What other strategies do you think the justice system should employ? And that's an interesting question, I think, to combine with, if I go down, I think I found a very interesting question from, there's a district judge who had a question. It's disappeared from my sheet, I think. There was an interesting question about BAME defendants going to the Crown Court. Here we are. This is Helen, who sits as a deputy district judge in the Magistrates Court. I know that there is a real problem of BAME defendants being more likely to be committed to the Crown Court for sentence than white defendants for the same offence. I've been very conscious of this when considering whether to commit BAME defendants to the Crown Court. Is there a similar problem for women? So I think those two could be connected.
Yes. Thank you. So taking the first question, why short sentences when they are ineffective? It's a very good question. There are popular beliefs which many politicians hold that somehow a sentence of imprisonment will serve as a deterrent. And I think it's a very naive position, really. It doesn't reveal any understanding of how deterrence works, if indeed it does deter anyone. So I think politicians and the media have, for the last 2-3 decades, engaged in a kind of populist punitiveness, which has led to an increased use of custodial sentences. Politicians will say, well, the public demand it. The public want to see responses, want to see more people in prison as a way of stopping crime. But actually, proper public opinion surveys don't show public support at all. What they show is that when given the details of people's lives, men or women, I would add, that members of the public are much more understanding and can see that it's community support, it's the sorting out the drug misuse, helping people find somewhere to live, helping people develop their skills so that they can get a job, so on and so forth. I mean, doubly difficult at the moment, of course. So I think politicians refer to public opinion, but they're drawing on media representations of public opinion and not what people really think. What could be done differently? More community resources, more joined up thinking between agencies, allied agencies to the criminal justice system, mental health services, drug services, so on and so forth, so that they're not competing for resources, but actually can work together. In Scotland, a presumption against the use of short sentences has been introduced. That seems to have been introduced without any difficult consequences in terms of people either getting longer sentences instead of a short sentence, sort of sentences outwitting the presumption against short sentences. The government is currently looking at residential units in the community instead of prisons, residential units for women. I think that we would need to look at such units very, very carefully. They're mentioned in the 2018 female offender strategy, but as I say, I think I would want to ask many questions so that they don't become mini prisons in the community. What does seem to be effective and what women say helps them most is having a place to go, a women's centre in the community, which will recognise that many of them are very vulnerable, that they've been subject to domestic violence and can receive help and support in addressing that, and where they can receive non-judgmental support for other things. The probation service has been starved of resources this last decade, 2 decades or so, while we've built more and more prisons. So I would want to see a reversal of the allocation of resources so that it's actually the probation service, community services, which get the resources in order to really increase the potential of helping people move away from crime.
Thank you very much indeed. Loads of questions coming in, as we know, interesting questions on the lack of intersectional data, transgender issues. Perhaps I'll change the subject completely a little bit and go to Kyria James's question, which is it correct that there's been an exponential increase in female sexual offending over the last few years, possibly because of the ubiquitous use of phone camera and social media evidence? And if so, how has this impacted on theories of criminology regarding women? That is a huge question, which I'll dump, I think, on Loraine. My starting point, though, would be, of course, offending which happens in the home is often invisible, and we have to look at the statistics quite skeptically because of the huge underreporting of all sexual offending. But how would you answer the question, Loraine?
Well, I would agree with your point about the underreporting of sexual offending. Nevertheless, I don't, what evidence we have, I don't think shows an exponential increase at all. And interestingly, criminological theories of the 1930s through to the 1950s focused on women's sexual behaviour, and it seems to me that women were either over-sexualised or under-sexualised in those theories of women's pathways into crime. I mean, I don't think I would want to view involvement in sex working, prostitution as a sexual offence. I know that some people do. For some women, that's obviously a chosen occupation. Other women feel forced to do that because they don't see any alternative. So I think if there is a perception that there's been an exponential increase of women, number of women involved in sexual offending, I think it's a kind of media-inspired perception.
Thank you. Back to you, Naima. I'm going to ask you Carol Maguire's question. Are any women's appeals successful? And linked to that perhaps is Catherine Grosvenor asking about the impact of abuse having a huge impact on women's attitudes on their current right to justice. And you might both want to come in on this. How well is the link between earlier abusive experience and women's current issues understood? Start with Naima.
Are any women's appeals successful? I think so, but linked to the question before about the lack of intersectional data, the Court of Appeal doesn't publish its data disaggregated by sex or gender, so it's impossible to know currently. So I think a very obvious first step would be to collect that data so that we can see and scrutinize it and analyze it. Certainly in the press, there have been a couple of high-profile successful appeals on women's cases, not least Sally Challen's case, which links to the domestic abuse and coercive control question. We are slowly getting better at recognizing the impacts of domestic abuse on offending, on pathways to offending. But my concern is at the moment that within the criminal process, domestic abuse can only be entered if it's pathologized. So if it's resulted in a mental health condition, complex PTSD, for example, severe depression, then that evidence becomes presentable in court. If you can get a clinical psychologist to stand up and testify, that looks a lot better than just a number of police reports saying, you know, this woman's been beaten up a bunch of times, or there's been a lot of verbal arguments at the home. So my concern is at the moment that we're still not relying on women's own testimony and own experience of abuse as credible enough to be presented within criminal cases. We still have to couch it behind the professional experience of psychologists and sort of medical experts in order to present that within a case. So I think that impacts on women's experience and relationships with their legal teams. If you disclose an experience of abuse and the response is, oh, well, we can't really use that unless you've got a mental health condition that's associated with it. So off you trot to go be examined by this doctor. And if something comes back, then we can use it. But if not, then not. That issue of believability and credibility is a real concern. When we map that against the horrifying statistics on the numbers of women who are abuse victims in society as a whole, we know that actually it's occurring at epidemic proportions. You know, we know that 3 women a week die at the hands of their partner. So, you know, there's a mismatch between the level of prevalence within society and how much we believe it or are able to take it into consideration in court.
Last word for you, Loraine, on that subject.
I won't add anything more. I think Naima has put it so well.
Right, okay, we do have a large number of questions. I'm sorry, we're not going to answer them all. There's a really interesting question on the training of magistrates and judges, which I think there are enormous issues about. We've been asked about the number of women in mental hospitals, and I'm glad that we were asked about that because it's a huge issue. I'm very conscious when I teach students about criminal justice, we ignore what goes on in mental hospitals. In many ways, it's more difficult to get out of a mental hospital when you're detained against your wishes than it is to get out of a prison when you're detained against your wishes. There have been many, many other questions, but I was asked to complete this session on time. I want to thank Amy and Lucy very much for the way that they've managed this digital festival event so wonderfully. They were difficult days, of course, at the moment for all of us. Not least, it has to be said, for those involved in teaching and learning. CUDA plays a fantastic role, I think, in keeping channels of communication open between the university and its alumni and the outside world. And that chimes really well with what I think has been our theme, what we've all been keen to talk about today, which is a plea for inclusion and not exclusion. I want to thank my friends Loraine and Naima very much indeed for taking part in this conversation. I'm absolutely ruthlessly ending it because we were told to end at 1:30, but I thank you very, very much for your involvement. And I think there is a slide that was going to be put up at the end, which has our contact details. We would be very happy to keep the conversation going if you would like to keep the conversation going with us. We all believe that it's a really, really important conversation. Thank you very much indeed. Bye.